right. Hi, everyone. Thanks for joining us tonight. Tonight's webinar is going to talk about estate planning for your college-bound young adults. Although it's not really just for the college-bound young adults. This really applies to any young adult. But when they do go away to college, it's even more so important that they have some planning in place. So tonight we have Jenny with us, Jenny Lamb. She's our marketing director, and she helps put all of this magic together. Thank you, Jenny.
Hi, everyone. Thanks for joining tonight.
Okay, so I'm gonna go ahead and
Before you start, I'm gonna release 2 polls.
sure, okay. So the polls are up. You can probably all see them on the top right.
They're up now. There's 2 polls.
So if anybody wants to participate in those polls, you're welcome to answer them at any time. I'm gonna go ahead and switch to the next slide, just some informational stuff. So our firm, SJF Law Group, we're here located in Plantation, and we strictly do estate planning, probate and trust administration, and pre and post nuptial agreements. So we specialize in those areas. So this is kind of near and dear to our hearts, estate planning for young adults. And we're going to talk about it tonight. It's not going to be a very long webinar because there's not too much to talk about. So we're going to get right to the point. And of course, if anybody has any questions, you can put them in the chat. I think everybody should be able to see them, right, Jenny? So if somebody else asks your question, you'll see it there. But feel free, we love questions, so don't hesitate to ask questions along the way. And then, of course, if you either forget to ask or you don't want to ask for whatever reason, or you think of something after the fact, you are welcome to just email us separately. So our polls here. Before today's webinar, how much did you know about estate planning relevant to college-bound adults? Not much, all new to me, and some but could use more clarity. That's great. And how important do you think this planning is? Extremely important. So that is correct. Correct answer. So, all right, moving on to our next one. Okay, so who needs this? As I mentioned earlier, it's not just for those kids going off to college, although that's really important because they're physically not going to be close to you anymore. But the age of majority in Florida is 18. So when a child turns 18, allegedly they are an adult. I know, I have kids. It's not true at all. But legally, they are an adult at 18, in Florida at least. Some states are different, believe it or not, but in Florida, they become 18. They become an adult when they're 18. So that really changes the playing field. If any of you who have had kids that reach this age before, you'll start to notice that, the doctors ask you to leave, or when you call to try to maybe make an appointment or get information, from your kid's local doctor, they're not going to talk to you anymore. And all of a sudden it's like a line is drawn in the sand. So when they're 18, because of HIPAA, which is a federal medical privacy law, the medical providers are legally prohibited from speaking with you and giving you information unless the adult child has given consent. So when you're here locally dealing with doctors and hospitals, they always give you those forms. So every time you go someplace, you fill out those pile of forms, and in there is going to be a HIPAA release that's specific to that particular doctor or hospital. But sometimes you don't run into as much trouble locally as you would when your kid goes away to college. Things that change the age a little bit: custodial accounts. So those are accounts that you open when the child is a minor, and usually the old law referenced 18, but usually these days they are going to stay in existence until the child turns 21 or 25, depending on the account. So the custodian named on that account continues to control that account until the child turns 21 or 25, at which time it just turns right over to them. But at least you have some control over it until then. So those are kind of the relevant ages. All right, so healthcare surrogate designation. So really there's two documents that you want these kids to execute as soon as they turn 18. Healthcare surrogate designation is one of them. And as it kind of sounds, this is where they are going to designate somebody to make medical decisions for them if they're unable to make them for themselves. But there's also a HIPAA release inside this document. And if for whatever reason the child did not want to designate somebody to make medical decisions, you could actually just do a separate HIPAA release, which is the more so important part of this document. But as we're going to talk about, they're both important. So healthcare surrogate designation. What happens when there's no document in place? So as I kind of mentioned already, you have no access to medical information, period. Nobody will speak with you. So if something happens to your kid and you're trying to get information and you're frantic, you're going to be up a creek. Sometimes people break the rules, of course, and they're going to give you information, but they don't have to. And it's a really bad situation to be in. Really bad, if they're far away at college, but even if they're local, and you're trying to get some information from someone and nobody will speak to you. So that's a bad position to be in. So without the document, who makes decisions? So let's say the kid is injured and they're incapacitated and somebody needs to make a medical decision for them. Well, first in line per the statutes, I should say before mom and dad, is their spouse. I'm going to assume that they're not married here. So they're not married here. So it's going to go to mom and dad. And so we capitalize the "and" because it's both mom and dad have equal preference to make decisions for the child. Now, if you have a nice, happy family, well, that's fine, no problems. But many people don't have that type of situation. And mom or dad might be estranged. There might be some contentious relationships, either with the child or between mom and dad. It could get very ugly there. So rather than be in a situation where the wrong party has the power to make decisions, it should be clearly laid out in a legal document, giving somebody the clear authority to make decisions. So, regardless of there being a mom and a dad, if the child executes a healthcare surrogate designation and chooses one over the other, that's a legal choice, and the other parent will not have any decision making ability. They won't even be second if there's an alternate person designated in the document. So alternates are really, really important, both in these documents and your own estate planning documents. So child names, let's say dad as its surrogate, as his surrogate. And then after dad, maybe it's an aunt or an uncle, or an adult sibling. But he or she names a couple of alternates. So the parent will literally have no ability to make any decisions for the child. So some actual real life stories here. Andrea, who works in our office, our own admin and intake professional, her daughter was up in Tallahassee in college and something happened and she was in the hospital, and Andrea tried to get information and they wouldn't speak with her. And that was a really stressful situation for her to be in, because it's far away and she couldn't get any information. And it was very difficult. Um, Not that this was her actual story, but it could also be a situation where the child is not incapacitated, but they don't want mom or dad to have the information. Something's going on, right? That they don't want mom and dad involved in or informed about. But have they executed the healthcare surrogate, you would have the right to the information. Another recent story was a colleague of mine, another lawyer, and she had an adult child about early 20s, and they got their first real job and they moved to Georgia and had some medical issues. He started fainting out of nowhere. So she flew up there to be with him. She's in the hospital and she's trying to call his various doctors, getting information and getting medical records. And she called me and she said, "I know I should have done this a long time ago, but I didn't do documents for him. And here I am sitting next to him in the hospital and I'm trying to get information and nobody will speak with me." So we had to drop what we were doing and quickly draft a document for her and get it to her. She had to have him sign it. He was capable of signing it, thank goodness. And they had to get it witnessed, and it was a hassle for everyone. So, but these are real things that happen. So, had they just executed the document, she would have had it, and it would have been very easy. All right. Don't forget to ask questions. So if anybody has questions, please put them in the chat. So, durable power of attorney. This is for financial decisions. A little less important, I'd say, than the healthcare surrogate. So the healthcare surrogate, the parents really need to have that in place for all of those reasons we discussed. So durable power of attorney is financial decisions, and it's a very broad document. It covers all sorts of stuff. Why would you need one? My kid doesn't own anything. They don't have any assets. You know, Slightly true, but usually they have something. But it's a little bit more broad than that. So, first of all, it's effective upon signing. So, this doesn't kick in the event, only in the event if they are incapacitated. So, your child gives you authority under a durable power of attorney. You could do stuff for them immediately. So, maybe they need your help with certain things. They want your help, or they're traveling, they're out of the country, they're out of the state, and they need you to do something for them financially related. You can use that power of attorney because it's effective while they're perfectly fine. It would give you the ability to access their college financial records. So everybody thinks just because they're paying for their kids' college that they have some, superpowers over it, but it's not accurate. And maybe, things will be okay, but they aren't necessarily going to be. And the child's an adult, they have privacy rights, and just because you're cutting the check doesn't mean you have access to everything. I've even had clients specifically write into the power of attorney that they could access the child's grades and report cards from college. So it's a pretty broad document, but it would easily give you access to the college financial records. If your child owns a car, and they absolutely should, if they have a car, the car should not be in your name. That was one of the things that we discussed last month's seminar on asset protection. So transfer the car to the kid. But if they do own a car, all sorts of things can happen, right? They can get into a car accident, and maybe the car is in the impound and somebody needs to get it out, and nobody's talking to you. Nobody will let you do it because you don't have any legal authority to do it. You don't have any special powers just because you're a parent. Maybe the car needs to be sold for whatever reason. Maybe the kid's, away and the car is here, the kid's away at college, or the kid's traveling and you need the authority to sell the car. Well, the power of attorney would let you. Maybe you want to speak to the car insurance company and the insurance is in the kid's name. So this power of attorney would allow you to do that. How about bank accounts that are only in the child's name? I see lots of people that have joint accounts with their kid. That's great, but usually it's one parent and not the other. And then the other parent has absolutely no access to those accounts, but maybe the child is responsible and they open their own bank account and the parent's not on it at all. This would give you the legal authority to access that account in many different ways. You could pull money out if you needed to, withdraw money. You could write checks. You could speak to the bank. Maybe it's beyond a bank account and it's a brokerage account because the child has saved money or been gifted money. So there's lots of times where you might need this power of attorney for some sort of financial account. And then obtaining any sort of financial information. So it could be credit cards, loans, all sorts of things. And then those are all assuming like the child is perfectly fine. But what if they actually are incapacitated and you need to be able to do something for them financially related? Of course, the power of attorney would then give you the ability to pretty much do anything under the sun. So any questions from anyone? I think that was probably pretty straightforward. So that's really it. There's not too much to talk about. It's medical decisions, medical information, and financial decisions. I think we have a handout that Jenny is going to put up there. There it is. So I don't know if I can see it. I'm going to click on it. If you click on it, it will download. We have a package that we offer for these documents for the kids, both the healthcare surrogate designation with the HIPAA release and the durable power of attorney. It's $850. If you were on this webinar tonight, we will give you a $100 credit towards that. But these documents are really important. Even if you don't use us to do it, use somebody else or download them from the internet if you really don't want to pay anybody for them. But get something in place, especially that healthcare surrogate designation with the HIPAA release. Make sure that's in there. Really, really important. Soon as they turn 18, they should do this. So any questions, please feel free to reach out to us at any time. Thank you all for coming. Jenny, I didn't miss anything, did I?
Nope, you covered everything.
Okay, thank you all again for coming. Stay tuned. So for the rest of this month, we are doing a mini webinar series. So we have a little mini webinar each week on a different document. So we're doing one mini webinar on trust, one on wills, one on healthcare surrogate designations for real adults, and one on durable powers of attorney for real adults, doing a deep dive into each of those documents with all of our different attorneys here. So please join us. And again, thanks for coming. Oh, Jenny put the link up, so I'll give you a second if you want to click on that link. That's to all of them, Jenny, or just to the next one?
To all of them. So you register one time and you'd be registered for all of the mini webinar series.
Okay, wonderful. You can also find this information on our website under the events and promotions, or all of our social media, which of course you can follow if you scan that QR code. Please follow us for lots of great information. Thanks, everyone. Have a great night.